85.9 acres to the City of Eagle Point urban growth boundary pursuant to ORS to Oregon Senate Bill 1537 from 2024. This property is described as Township 36 South, Range 1 West, Section 10, tax lot 1202 and 1203, and Township 36 South, Range 1 West, Section 11C, tax lot 300, and are located at Bingham Brown Road and Alta Vista Road in Eagle Point. And the applicant is Eagle Point Bingham Development, LLC. Again, file number 439-26-00002-LRP. We have Ted Zook and Kristen Mays of our planning staff, and our legal staff today is Pete Philbrick, Deputy County Counsel. And at this point, can we have the admonishments and rules of the public hearing read? Please, Pete.
Thank you, Mr. Chair. Please remember to direct your testimony and evidence towards the criteria or rules set forth in the published notice for this hearing. Those criteria, rules, and standards will be further outlined for you by staff momentarily. You may also direct your testimony to other criteria in the comprehensive plan, land development ordinance, or other land use regulations which you believe apply to the decision. Understand that a failure to raise an issue with statements or evidence sufficient to give the decision makers or other parties the ability to respond to the issue will preclude or prevent your appeal based on that issue. We are making a verbatim recording of the hearing. In the event of an appeal, it may be necessary to transcribe it. Therefore, when you testify or comment, please begin by identifying yourself so that anybody reading the transcript of the record will know who is talking. We will first hear from staff and the applicant will follow. Then we will hear from those who wish to comment in favor of the application, and we will hear from those who are opposed. The applicant has the burden to prove its case, thus the applicant will have an opportunity to respond to the comments and opposition. Once everyone has had an opportunity to speak to the public hearing and the record will be closed unless there is a request for continuance. If so, then another set of rules will apply. However, if there is no continuance, then the commissioners will proceed to deliberate toward a final land use decision. Finally, we have a couple of housekeeping issues to resolve. First, this is an opportunity for commissioners to announce whether they have any ex parte contacts. If ex parte contacts have occurred, please discuss the nature and the content of the contact or contacts so that the parties are aware of the substance and communication when the hearing is open today and have an opportunity to rebut any evidence obtained ex parte. And second, this is an opportunity for the commissioners to announce whether they have an actual or potential conflict of interest with respect to the matter today or the applicant. If so, the commissioners can discuss the nature of that actual or potential conflict and address how they wish to proceed. Are there any ex parte contacts or conflicts of interest to report?
I have none.
I have none.
And I have none.
Rules of conduct for the hearing are as follows. Only the chair or a member of the Board of County Commissioners may question a speaker. There will be no interruption of a speaker from the audience and no debates on the floor. Applause is not permitted. A speaker may criticize a proposal, the board, or an agency of the county, but the speaker shall not argue with another speaker directly. Any speaker may present an opposite view, but not in personal terms. A person wishing to speak shall raise his or her hand and be recognized by the chair conducting the hearing. After being recognized, the speaker shall state his or her name and address before proceeding with his or her statement. And the chair may limit the duration of any presentation to the time necessary to cover factual information. Repetition shall be avoided. Thank you, Mr. Chair.
Thank you. And with that, we will request the planning staff report. Sorry, Charles, I didn't mention you were here.
Oh, that's all right. I'll mention it right now.
You're here.
Yeah, Charles Bennett, 10 South Oakdale. Good afternoon, Commissioners. The application before you is request for an amendment to the Eagle Point urban growth boundary. So we will look at a map. This is the general map that was submitted by the applicant. It shows the vicinity. It's on the south side of Eagle Point, south, and you can see it in green. And it's basically the proposal is on the south side of Eagle Point Urban Reserve number 4. So our criteria, the Senate Bill 1537, currently written into the statute as ORS 197A200, provides an expedited process for amending urban growth boundaries, a one-time process for each city, which does circumvent some of the existing state and local criteria. However, Section 50 2 requires the county to approve an amendment to the urban growth boundary made under Senate Bill 1537. That complies with sections 49 through 59, and the county shall cooperate with the city to facilitate the coordination of functions. The urban reserve management agreement between the city of Eagle Point and Jackson County requires, under section 5E, the entirety of Alta Vista Road right-of-way transferred to the city. And I'm not going to read all this, but this is the urban reserve management agreement, a portion of it. It basically says this is an existing agreement between the city and the county to provide an orderly transition of urban services from county to city jurisdiction and administration as the urban reserve transitions from a rural to urban character. And the second bullet point is an important one where it talks about when a proposed urban growth boundary amendment will result in a significant impact to the county road already within the city limits or existing UGB, such that the proposed amendment amends on said county roads for proper traffic circulation, then a nexus is found to exist between the proposed urban growth boundary expansion and said roads. And Alta Vista is a nexus road, but there are other components that also are important to recognize. And that is in 197A 200, the part of that Senate Bill, section 55 3C, requires sufficient connectivity to existing and planned transportation network facilities, which brings in our Jackson County TSP. So the city of Eagle Point has already adopted ordinance 2025-5 and ordinance 2025-6, approving the urban growth boundary amendment, annexation, and zoning designation. The area annex is depicted on the map, and it's in the shaded color, but it leaves out Bingham Brown Road, which this development connects to, and a portion of Alta Vista Road. So this is the zoning map for Sky Ranch, which shows the extension of Robert Trent Jones Boulevard, which is the dark blue line. It comes down from the city into this development, connecting to Bingham Brown Road. It goes to the west, and development frontage on Alta Vista Road, which is the dark red line. And then there's connection of this development, like I said, on Bingham Brown Road. The proposed urban development partially relies on rural road standards, which urban road standards, where urban road standards are applicable. There's about 356 dwellings that are proposed with this development. Even though we're just looking at the urban growth boundary today, we're not talking about the development. It'll be in the city's jurisdiction, so we don't have to worry about that component, but we do have to worry about the impacts of the roads on our systems. So this is this is the transportation system plan criteria that we have in our transportation system plan that clearly supports conditioning the urban growth boundary to ensure jurisdictional transfer of the rights of way. So I won't read all that either. And then come down to the conditions. Staff worked with roads and the county council on proposed conditions that require the rights of way of Alta Vista and Bingham Brown Road be included in their urban growth boundary and transferred to the city in order to allow those facilities to be upgraded to urban standards, to the city's urban standards. Yesterday afternoon, we received an objection from the county's an objection to the county's proposed conditions from the applicant, starting on page 231 of your record, so you may not have had a lot of time to look at it, but it's in there today, hopefully. The proposed urban growth boundary amendment will have a significant impact to the county roads with 5,300 plus ADT, average daily trips. Thus, the Urban Reserve Management Agreement, the Jackson County TSP Transportation System Plan, and Senate Bill 1537 all support the inclusion of Alta Vista and Bingham Brown roads into the urban growth boundary. These are the city conditions. The county today is not reviewing, like I said earlier, a private development. The county is supporting the adjustment of the urban growth boundary, which should include the significantly impacted county roads. But, you know, like I said, staff is recommending approval with those conditions, and that's all I have, unless you have some questions.
Questions? I have one. So our urban reserve management agreement did not identify this as on the nexus list, which I know is not absolutely necessary. We can still find the nexus through other means, but do you have any idea why that wasn't contemplated in the urban reserve management?
Well, just to clarify, Bingham Brown Road isn't mentioned specifically in the urban reserve management agreement, but Alta Vista Road is.
Sure.
So it is. There is a nexus. Is that what you were asking about?
I'm asking
Bingham?
about Bingham Brown specifically, yeah.
Yeah, we do have the Department of C. Lambert from the Roads Department. Maybe this probably goes back to the RPS process, regional problem solving, where this was worked out between the roads and the city. So I'm not sure exactly why Bingham Brown wasn't included in as a nexus road at
And
that
like
time.
I say, I'm aware that it doesn't have to be. We can
Correct.
prove that nexus with other evidence, but I just was curious if we have any idea why it wasn't contemplated in that nexus list. Yeah, please.
Commissioner Dyer, members of the Commission, Steve Lambert, Roads and Parks Director, for the record. I'm not 100% sure why Bingham Brown Road itself was not included in that. As Mr. Bennett mentioned, that was all done part of the RPS process about 15 years ago. I think the fact of the matter today and what we're looking at with Alta Vista Road is Alta Vista Road was clearly identified in that, which is why we, as the Roads Department, working with the Development Services Department, clearly feel that Alta Vista is the development that we're seeing potentially from this, the trips generated that we're seeing from this development per the traffic impact analysis create a significant impact on Alta Vista, which then triggers that nexus requirement. But to your question about Bingham Road, it is my understanding, yes, that the other provisions of the enabling legislation for this process that require a tie to city services, you saw the map before you that development was going to tie into Bingham Brown. There's going to be a lot of trips on Bingham Brown. That's a very narrow road, not built to current county standards and substandard.
Yeah, I'm not questioning whether there is a nexus. I just like to say I'm curious as to why it wasn't included.
Yeah. I wasn't at the table 15 years ago. I couldn't tell you exactly why.
Me neither.
Thank you.
All right, thank you. Okay. No more questions. We will move to open the public hearing, and we'll hear from the applicant first.
Good afternoon. My name is Dan O'Connor with O'Connor West, 670 G Street, Suite B, Jacksonville, Oregon, 97503, representing the applicant. It's a pleasure to be here today, and then just want to, for whatever it's worth, is we have these little dust-up squabbles about certain provisions, but just the underlying tone is a position of respect for the people sitting before us, the county staff, and the departments we work with. Anyway, just wanted to kind of lay that out there. And so I'm just going to step back, walk through this process a little bit. This is Senate Bill 1537. It's a one-time UGB that allows really a one-time UGB amendment where you have certain workforce housing requirements. And it's a unique legislation which has caused confusion and some miscommunications. And so as part of the process, just the background is with Skycrest Development, they were part of really a competitive process to be awarded the opportunity to pursue this through the city, which is at first blush it doesn't seem to matter, but it really does in the sense that it's not our traditional UGB amendment process. And so when Skycrest was awarded the opportunity, we reached out to the county for we submitted a pre-application conference request where a bunch of these issues where we have the county, the city, the various departments impacted would be in a room discussing these exact issues. You may recall we had a work session on this specific application because of the legislation. It's like where it's what kind of process do you go through in this? And at that point, it was decided during our work session that, hey, it's just a board order, you know, and so then we were instructed by the county that, hey, we are rejecting your request for a pre-application conference because it's not necessary. It was going to be, my recollection was going to be more like a consent agenda item type action. The county council changed position for whatever reason. I'm not questioning the validity of the reasoning to change that, to switch it to a more formal type of UGB application process. In the county, in an effort, I believe, to do a favor for us, we're waiving the pre-application conference requirement. And so this is just one of those unattended consequences of moving this type of thing forward. And so that's kind of why we're here last minute. And then from the client's perspective is time is money. We're trying to be efficient. It's been a rigorous process for I think like 18 months now. And then we have we received the staff report, and we were notified about the county's position before this staff report. I want to be absolutely fair to the county. We were notified that this position was coming down. But then the concern that we have as an applicant trying to move this forward is, well, man, I wish we would have known about this earlier, because what we would have done is with the Alta Vista, let's just be clear, there is no issue with Alta Vista. I've had discussions with the city about that. Hey, it should have been as a condition for the UGB amendment. The council is vetted on it. They support that position, so I'll just lay that out clearly. But then we get the staff report on, got it Friday. And then, so then working with the city, because there's all sorts of confusion about what has already been jurisdictionally transferred, what has not been transferred. And with all due respect, I've reviewed the IRMA. You look at the four corners of that document, the Big and Brown Road is not there. And then to support our position that it is not appropriate to have that condition for that road to be a part of this is in the findings of the staff report itself, which state as to section 55 of 1537, the traffic component, the finding states this. This is from the county. Findings of fact, Alta Vista Road, being a nexus road identified in the IRMA, requires the city to request transfer of jurisdiction as a condition of approval consistent with section 55 above. That is the entire finding to support the county's position that this section 55, there is not one mention of Big and Brown Road in the county's findings to support the condition that includes both Alta Vista and Big and Brown Road. So there is no record support for the county's position on that issue. That being said, working with the city, do you have my maps? Oh my gosh, there you go. This is Exhibit A, and I put the actual IRMA itself in the record, not just paraphrasing it, but the actual document. This is Exhibit A that shows these roads, and as you'll notice, there's no Big and Brown Road as part of that. That being said, I'll go to the next one. Am I? Thank you so much. So, okay, with that being said, this is the maps I received from the city of Eagle Point yesterday, working with Mike Cupston, the planning director. There is, you can tell Big and Brown is still county jurisdiction. The one section of Alta Vista on the north end is county jurisdiction. There is no issue that jurisdictional transfer will occur. It's in the urban growth boundary amendment record. There's the possibility that the little section off property is still being maintained by the county. There is confusion on the rest of it, where those kind of, I can't remember, is it Robert Trent Jones that heads north just to the right of Vista on the map, all the way to Riley Road. There is confusion as who actually has jurisdiction. And I went into the county road records for 3 hours, identifying everything, and I found a clear an order that everything west of Big and Brown Road clearly was transferred to the city. I believe the confusion occurs because even those on where it says R112, it's in the UGB, and then there's a little subdivision that on the diagonal portion where when those were platted, well, the far right, when they did an amendment to the plat, there was dedications to the city, and it was accepted by the city engineer on the plat maps for those dedications. And so that's where kind of the confusion lies on that. So as to Alta Vista, Mike Upson is very clear, and I have this solution in my language and be very precise because this is what I have basically authority to say. That section north of Alta Vista, you know, right there where our stuff is, no question. That was just an oversight. It wasn't included as a condition. As to the remainder with the yellow section, because they were confident that that section in front of the subdivision had already been transferred. The feeling is, not committing the city at this point, but that this whole section of Alta Vista all the way to Riley should probably be transferred to the city. And so there would be, when you do the transfer, like when I looked at the stuff on the area to the west, and this was my other objection, is on the statute, was it 370? I cite it in my memorandum. That is very specific procedural requirements for the cities to comply with. And like on that section I mentioned just to the west of Big and Brown, there's an affidavit of notice that complies with the procedural requirements. It's a whole thing. My objection there was we as the applicant we have no ability to comply with that because we're not the city. That was just the nature of my objection there. And so in relation to the Alta Vista component, especially that, we propose a solution to the issue there. And that is a condition of approval, basically instructing the city that this is accepted as provided as condition to annexation, because we have not annexed the UGB property into the city. And so why we're requesting that is because if that's allowed, then we don't have to go back to city council, do an amendment to the UGB to add this one statement. And I believe that if we can avoid that, then if we just have it as a condition to annexation, it's just taken 60 days off the table to be more efficient. Then as to Big and Brown Road, we are definitely, as the applicant and property owner, open to that discussion to amend the URMA to do the jurisdictional transfer on that one also. And then, I'm not speaking for the city, but based on my discussions with the planning director, that is just, it does not have authority of the council, definitely open to discussions. In our grand scheme of things, it does not make sense to have a county road gap, between urban level road, because when we develop down on the southern end, we'll have to make improvements to road. I'm sure it'll probably be curb, gutter, sidewalk. It's a little premature to maybe do that to actually do the jurisdictional transfer at this moment, because there's intervening property ownership. That the little line you see on the north end of the map or in the upper end of the map, that is an intervening property owner. That's not even part of the UGB. And so our request is really, hey, can you let us fix that issue on the annexation condition of this, and then on the Big and Brown, we want to move that forward with a discussion with the city and the county, because according to the city, they didn't even got the staff report. They were surprised that this jurisdictional transfer was being proposed, and I'm not saying whether right or if it's true or not, but they're saying we didn't even get any notice of this, and they're the party that's supposed to be at play here on these maintenance obligations. And basically, I think that's all I have, unless you have any questions.
So, go ahead. So this expedited process, obviously, things probably are going to get missed that wouldn't normally.
Right, exactly.
But I can't imagine there wasn't some contemplation or the foreseeable that this part of Big and Brown would be included or requested in the annexation, considering it's serving a major ingress to the development, and as part of a transportation system. It would seem like it would come to the attention of everyone involved that it probably would be requested to be part of the annexation.
Yeah, and where that issue probably came up is when the zone change was done and the TIA was done as part of it by Kim Parducci. It was determined, Matt, correct me if I say something incorrect, it was determined there was no significant impact to that road. And so that's probably just, and Commissioner Dyer, that's what I'm just saying, it's just kind of like, where it kind of got lost in the weeds. And like, to reemphasize, our plan would be, because where that development is proposed, is the development's going to start north and head south. And so there's going to be a significant time period. I know they're anxious to get going, but there is some time for us to get that figured out before that actual connection is made.
Any other questions?
Yeah, Mike, maybe you answered it, but my question is on Big and Brown. Is there planned egress or
Yeah,
ingress? There is a plan
There is.
to Big and Brown.
Yep, there is and it comes in south of where that intervening property boundary is located.
And knowing the area a little bit, Robert Trent Jones Boulevard basically serves the golf course.
Right.
And coming straight through, I can imagine that would be traveled to get to Big and Brown instead of taking Alta Vista. I would imagine that would be a fairly, I don't know what the transportation study showed and why it didn't show major, but to me, just common sense tells me that it would be used fairly extensively.
And I can't argue with that, because I live on the east side. When I go to Eagle Point, guess where I'm going?
Right.
I'm going, I think a lot of the traffic shows when they do their modeling, right, is most of it was continuing on Alta Vista to Highway 62 at the interchange and using that. And so.
Well, I think transportation was a huge discussion at Eagle Point as well to the residents, because
Yes.
those are all tiny roads, and Big and Brown is heavily used already. It is a concern of safety to not have it adopted to urban setting than staying rural, because it's not going to be, it's not really rural anymore anyway.
Right, and we're on the same page with that, with bringing that, I mean, if, and we would work with county council, is it appropriate to amend the IRMA before you do that? Or can the city and the county just stipulate to a jurisdictional transfer without amending the IRMA? But it's like, and I understand where you guys want that to happen in the relatively near future. But then I still have based on what the agreement is and the lack of findings, I mean, if there was some sort of time frame to initiate that discussion without slowing my development process down, we are open to that.
So I guess my question would be to staff then. Does that create any issues or concerns on staff's behalf if we were just to delay the amendment to the IRMA, but have this condition stipulated in this approval or application?
Well, I guess the concern is, and first, I want to say with ultimate respect back, so there's
Thank
no,
you.
this is just a friendly legal argument, I guess. The concern, I guess, would be that the UGB expansion is going to be with the city, and as you pointed out, this is with the applicant. So I don't know that there is a time issue if the city is the one that's going to be upgrading these roads at some point, how that slows the applicant down. If they're starting from the north side and coming down, you would think there would be sufficient time on that. A couple things I would like to point out. On page 181 of the record, there was a memo from Roads specifically talking about Alta Vista and Bingham Brown. And then that was dated April 7th, 2026. And also on page 146 of the record, this was submitted by the applicant, and then you can, if you look at that map there, it will show you that that lower portion of Bingham Brown that abuts the development was to be included within the UGB. Later on, we got a map that came in, I believe from the city council's resolution on it, and that was missing. So there was at least a portion of Bingham Brown that was at first, when it came in with the application, that was identified as something that the city would be taking. The county's position on it, however, and Steve maybe talked about this a little bit more about the road aspect of it and a number of vehicles on it, is, I think we can all agree, it doesn't really make a lot of sense if you have that one section down at the bottom and then you have another section you have to get up there. I guess the long and short of what I'm trying to say is I'm not really sure what benefit there is if we don't just condition it now, and the timeline is the timeline. When the jurisdictional transfer happens and the city takes over, it will probably be in conjunction with the development process, because it's not actually the developer that's going to be doing the work on the city road at that point.
Yeah, and I just want to, I'm sorry.
Yeah.
Oh, Ted, one quick question on this map that has the included roads. Is that from January of '24 is what the date stamp on the other side is? I just want to clarify when that was provided in the record, so that it is or isn't a surprise to the city.
I would, this is what was submitted, and if that's the dates on there, I'm going by the date that's on there. I may, if I can, direct that to Matt, who, do you have any recollection of when the date on that? It's on page 146 of the record. It was What I can tell you is, you see it's submitted by the applicant. It was the map that was given to us. So the date on it, I can't tell you how that came about, what that date is.
September 24.
Yeah, and if I may just speak to that issue, there was communication. It was in talking with Mike and Luke Upston, when I say Mike, and then talking with Matt Brinkley, but there was a misunderstanding too, is that there was an assumption when the request came in that it was that road section was specifically listed on the IRMA like every other one. And then there was, so I'm not trying to say, oh no, they blind, I mean, that's not our position at all. So just to be clear on that.
Yeah, and
Nor
to be
ours.
fair on that, well, I'm not saying anything conversely. It was just, we had assumed there would at least be part of Bingham Brown. That would be part of it, and then the map came out and the resolution was already done.
And this is from the city of Eagle Point. We missed it. They missed it. They missed and in their defense, I mean, there's correspondence going, there's 3 competing things and all this, and they're like, hey, sorry we missed it. And so in terms of what we're trying to do is, hey, we're open, to get that Bingham Brown section in. It's just, if we can condition the way so this UGB, because it'll require some participation by the city on that, that's all we're asking is, hey, I think in principle, we're all on board for the same thing.
So essentially, it's just to be able to get started early, to avoid further delays, but not opposing the condition to be executed, I guess, at some point.
Yes. And in fairness to the city is like, I mean, they will be the ultimate decision maker on the Bingham Broad Road. But based on discussions, and I can say this without hesitation, based on discussions that I've had with the city, that seems like the logical thing to happen.
Okay, so I guess I want to make sure I understand this. If we allowed the condition to be delayed until the IRMA is amended by the city, which was what has to happen in that case, and the UGB, they need to rehear it or whatever needs to happen. If the city at that point decides it's not necessary, then are we bound to not having that annexed in if we didn't specifically condition it here to be done at this hearing? Do you understand what I'm saying? I mean, is there a risk that we're taking that at that point, if the city says, no, we don't see the necessity, we don't see the nexus, we're not going to condition that?
And then let me just add one little, if I may, is keep in mind, you still have another bite at the apple with us.
Yeah.
Because this is the first of 2 UGB amendments. And then there could be, just if it helps, it could be like no further UGB amendments or, as a stopgap, that I'm just looking for a mechanism that keeps what you guys want accomplished.
Randy, that's
Oh, sorry, Randy. Go ahead.
Well, you guys are pretty much answering all this stuff. To me, it's super logical that you look at the map. I mean, there's 2 roads that are going to be utilizing Bingham Brown from this development. So yeah, you have to bring those up to city standards, and it only makes sense that you don't have that little gap there. It's just the mechanism of making sure that's in the UGB.
My question is, I guess, that I again, this road being annexed and, brought it to city center, I don't think there's any question that should be done. If we can somehow allow and effectuate them to avoid some unnecessary delay and not in any way damage our ability to make sure that annexation is done on this portion of the road, I think that's a concession we should be looking at, if there is a way that we can do those things at the same time.
My view here is that if the county doesn't impose the condition now, that it will be difficult to compel the city to come to the table later.
And that was my question, so. Okay.
And I'm not sure if what Dan is arguing is that is necessary for a nexus road to be included in the IRMA before it can be, the jurisdiction can be transferred, because I think county council just has a different view about that.
No, and that's, I respect that. It's, if a jurisdictional transfer can occur without an IRMA amendment, and I'm not saying that's not allowed, I mean, we can do that. But if county council had a process, no, you got to amend the IRMA first, we would comply with that. But if that's not a requirement, that's fine.
Yeah, that's the understanding I have, that if a nexus is found to exist regardless of whether the road was previously listed, it can be included. I mean, and again, I'm not the expert here, but that was my understanding, that it didn't have to be amended to include, I mean, a listed road is just a convenient list of saying, hey, these are absolutely, but if you found one that has the essential nexus, you can identify that without amending the IRMA, as far as I know. And I'm, like I said.
That's my view as well. I think the roads that were specifically listed in the IRMA were listed because they were indisputable at the time, 15 years ago or whenever that was negotiated.
And then,
But I don't think it's I don't think it's necessary to establish a nexus on different roads now.
well, I'd probably disagree with that, because when the IRMA was entered into by the parties, the county and the city, nothing has changed in the urban reserves. I mean, it was all they have remained stagnant. Nothing, so whatever assessment was done at the time it was entered. And maybe my reading is strict of the IRMA, but it's, my interpretation of language, it's pretty strict on, what establishes the nexus in terms, or what can trigger the jurisdictional transfer based on the language of the IRMA itself.
If I may interject, and just to keep the conversation going on that, there's a lot of emphasis on the IRMA for Bingham Brown. I do believe we could probably get the nexus there for it. I don't, council can talk on it, whether you need to change the IRMA or not. I don't believe so myself. But there's also the transportation system plan. And the transportation system plan talks about pursuing jurisdictional road transfers, basically when the traffic becomes a burden, for lack of a better word. I think Steve would probably be the best one, because I am going out on the ledge here and start talking about transportation things, and that's not necessarily my forte on it, but I think he can probably give a little bit of overview on that.
Steve.
Stop making them squirm there while I talk.
Yeah, again, is this an absolute list, what is on the IRMA, or is it just the known at the time? And then, I mean, I wouldn't imagine, you seem like it would have to have some flexibility, because roads are built and roads are added that may have a necessary, yeah.
I'm happy to answer.
Please, yeah.
Well, he's signed up. Let's hear the rest of the testimony, yeah.
Do you want me to, or do you want to?
Yeah, well, Dan can certainly come back up and answer after.
So sitting here listening to this conversation, I was thinking about your original question of why Bingham Brown wasn't included as a nexus road. Again, I wasn't at the table, but I think it's pretty easy to deduce that the nexus roads, as referenced and written in the IRMAs, whether it's Eagle Point, Medford, or anybody else that we have these IRMA with, are roads that at the time we executed those agreements were already in the city limits or UGBs, right? The rest of the IRMA discussion was talking about how do we deal with roads that, that as the city expands out into the IRMA, or into the, urban reserve, it expands its UGB out, how are we going to deal with these? These roads that, we have a lot of roads, whether it be in Eagle Point or any city, that are already in the city limits or UGB, Hanover have already been in those. So the attempt at addressing those nexus roads in any of these IRMAs was, we don't necessarily have a trigger as the cities expand out into the urban reserve for these roads that are already in the city limits or UGBs, but we're going to call out a handful of really important roads that should be transferred at that time. So Big and Brown was not in the UGB, it was not in the city limits, so it therefore would not be called out as a nexus road.
And amending the IRMA anytime there's a road that appears to be something would be impractical.
We do jurisdictional transfers with cities all the time, and we do not, they're not specific nexus roads. We don't go and amend IRMAs. They're just roads that we agree on with cities, be it
Yeah.
Central Point, Medford, Phoenix, Ashland, we just did one that should be transferred. So there's no need in this case to amend the IRMA.
That would seem like the reasonable
Yeah.
process.
So I can keep talking, or you can invite Mr. O'Connor back
Yeah,
up
I
to
mean,
finish.
yeah.
Go for it.
Dan O'Connor, we have a proposal. We would not, just to keep this going, is that we, the applicant, would not object to a condition on, was it
Big and Brown.
Big and Brown. What was it? On subdivision?
Yeah.
Yeah. That upon, excuse me,
At time of subdivision.
at time of subdivision, it would be, a jurisdictional transfer would be required. A jurisdictional transfer would be required.
And that's something that the city of Eagle Point would have to agree to.
Well, we would, yeah, I mean, you could impose that condition, and then it'll be on us to make sure the city, they would need to comply with that, but then that would motivate us to get that done, because, as I said before, the discussions I've had with them, there was not an objection
Yeah.
to that per se.
I would say that seems to satisfy our condition. I mean, if there's a condition on them being able to proceed by getting the jurisdictional transfer approved and done, that's essentially the same condition we're asking for, it seems to me.
I kind of disagree. I think we're kind of insisting on it being,
But it's still a
Put in
condition that they
place
have to
now.
follow.
We get back to the issue of the applicant is a private party versus the city. And if I understood what Mr. Connor was proposing there, was that now the private party would compel the city somehow to
We would help
jurisdictional
facilitate.
transfers. That,
Yeah.
so I'm not really sure. I'm going to probably ask Pete to follow up on that. I'm not sure that
It does put the
what's
risk
the
and
difference
onus
on why
them.
we, yeah, what's the difference if we just don't
Yeah.
compel the city now? And the timeline would be then between the private party, the developer, and the city to determine when the road needed to be done. Obviously, there's going to be time until that development's done. I would believe that there was time for them to negotiate with the city when we think this road is going to be done, but having the developer now compel the city kind of takes away our ability to ensure that that happens. I'm not sure what the legality of is. Who would we go,
Okay.
for lack of better terms, who would we go after if it didn't happen?
The developer is the applicant. I think in either case, it would be incumbent on the applicant to ensure that the condition is met
Right.
before the UGB amendment becomes effective.
And that was essentially what I was saying, that they still have that condition that they have to meet before they can continue with the development, that of course is the motivation for them doing this. And
Right.
Why, and if they're not able to meet that condition, we wouldn't be the ones that would be going after anyway, because it's, we're not the developer.
Right.
What I would say, though, is that at that point, it's already annexed into the city. We would have no recourse.
If
It
there
would
were
be between
another
the city and
development,
the developer.
if there's another development contemplated there, then we would be able to impose that same condition, I would think,
Yeah, that's,
on a future application.
that would be a different,
Yeah, maybe it's a
Animal.
little convoluted, I don't know. It seems like there's a semantic thing going on here. The condition is still there. It's just predicated on if there's another opinion and another explanation from staff, I'd be willing to hear it too, because I want to make sure that we're getting this right.
Well,
I guess one of the unknowns we would have is if there's another UGB expansion coming in, is it going to be the same developer? Is it going to be a different developer? Because now we would be looking at the city and saying you have to bring your roads up to these standards because of this other development that you have, and now we have a different development with a possible different developer on there. It just, to me, it just doesn't seem very clean, but I'm not giving you a good,
Yeah,
I can't give you a legal.
I don't disagree. It's not clean, but
I have a
is it
question on this
reasonable?
one.
Yeah.
The city already annexed this piece, sans Big and Brown, correct? They've already got a process to get that done?
No, we have not done the annexation.
It's done.
Oh, is it done?
Yes.
So then how would I,
They've been noticed.
That's the problem.
it's already been
Already
approved?
annexed it without that.
Matt Brinkley, Green Top Planning Development Research. What I think we're trying to propose is that with the development application, a subdivision for the land that is actually adjacent to Big and Brown and would trigger any kind of improvement to Big and Brown, that would be conditioned on jurisdictional exchange at that point. That way there is actually a constitutional nexus between the development that is taking place, the impact that is occurring, and the mitigation that would need to occur at that point, which is the improvement of Big and Brown Road. And that's, I think, what we're trying to propose here. And that gives the county a huge enforcement mechanism because the subdivision can't take place, land can't be divided, lots can't be sold, and development can't occur, which is what developers are trying to do. If that can't happen, that's a problem for them, and that gives them a pretty significant incentive to have the jurisdictional exchange occur. And you're correct, it's a private party. The applicant can't compel the city of Eagle Point to, actually do the jurisdictional exchange, in which case the subdivision can't happen. The impact that would require the mitigation, the improvement of Big and Brown, would not be able to happen at that point. And so those things all kind of work pretty well together. And I would also note that, so we have the UGB, application of comprehensive plan designations, zone change, annexation were all considered by the city of Eagle Point, and that's in your packets. And within that, there was a TIA that Charles referred to earlier when he mentioned that there would be 5,000 average daily trips. That's from this TIA that was performed for the zone change, which your county roads department reviewed and didn't really provide any comments to, other than there needed to be a jurisdictional exchange pursuant to the IRMA. Not because of any particular impact that was found, but because of the IRMA. This TIA, which was accepted as part of the record for a zone change and an annexation that are done for months now, found that there was no, let me see here. It is concluded that the proposed zone change with reference mitigations can be approved without significantly affecting any existing or planned transportation facility under Eagle Point, Jackson County, or ODOT jurisdiction. The only improvement on Big and Brown at that point for this particular application was a new stop sign at the corner of Alta Vista and Big and Brown with the lights on it like at 140 to alert motorists that there's a stop there. In the future, and this will be happening relatively soon, Eagle Point will be updating its own TSP, and that will be another opportunity for the county to suggest that there would be a jurisdictional exchange. But in the short term, you have a lot of enforcement by conditioning any development application, subdivision for the land that is adjacent to Big and Brown on jurisdictional exchange. And that, to me, would make a lot of sense because it connects those things. The development that creates the impact that requires any mitigation, which is going to be improvement of Big and Brown.
Yeah.
I have a quick question on that. Mr. Brinkley, how would the county have enforcement if on development inside city land?
Yeah, so that's a great question, Commissioner Roberts. And this is something that I think really that should be understood. Even without a jurisdictional exchange, it's a county road until there's jurisdictional exchange or until there's a jurisdictional transfer, which means that county roads is noticed and they get to impose conditions. So your county roads can impose conditions at that time, in addition to what we talk about today, on that application. So you would see that application, the county would, and you would have an opportunity to say, there is this condition that we put in place on May 13th, 2026, and there needs to be a jurisdictional exchange. And until that occurs, that subdivision is not actually in effect. The way that you enforce that is the way that we enforce all of these land use things. If the city somehow decided, well, we're just going to let the developer go ahead and approve subdivision plans, approve a plat, a preliminary plat, for example, then the county would be able to intervene. So you could take the applicant and the city of Eagle Point to LUBA, if that were the case. I mean, these are the enforcement mechanisms that you would use in any case.
So, to me, it seems like, my intention here and my goal is to make sure that we put in place whatever conditions are necessary to ensure this exchange, this jurisdictional exchange takes place without us having to be the hammer on, unnecessarily create us as some sort of party to a dispute later, if that's possible. So what you're saying now seems like that it brings us into a future, again, potential dispute that we probably could avoid.
Well, I think you're in the same position now with the current condition, the way that it's written, because you would have to enforce that condition too, especially in this case with Senate Bill 1537, where kind of the way that the existing land use rules work with a conventional UGB and the way that they work with this kind of UGB amendment are untested and different. It's possible that you would find yourselves in the same kind of enforcement position, exactly the same enforcement position, but without having something that would actually encourage, for example, a developer, our client, to do something about it, to say, City of Eagle Point, we need to get this jurisdictional transfer done because I want to develop. So.
And I get that. And Steve, I'm sorry, Steve had something to say, I'd like.
I signed up.
He signed up to speak.
Okay. All right.
I'll just conclude ours, and then, yeah, we think that's a valid mechanism for enforcement. And then the one thing I just want to emphasize is it's a back to the findings, is because this goes to DLCD for final review, and they're the kind of the ultimate decision maker. And in your staff report, you don't have a single finding of demonstrating that the Big and Brown, it just references Alta Vista. And so this way, it's like more of a sure thing is that, I know you guys want that road transferred. We're offering a mechanism that's, no one wants to get in a dispute, but if there's, just from 30 years, oh my God, I can't believe I said that, of experience in this, where there's a condition that some other jurisdiction imposes, I've never had one jurisdiction, we're just going to ignore that. you know, and so for practical purposes, I think it's a functional mechanism to ensure that you guys get that road transferred, and you're putting the impetus on the private developer to help make that happen, where we're motivated. So, thank you.
Thank you.
Commissioners, Mr. Lambert, Roads and Parks Director. Again, I do want to take the time just to respectfully disagree with a few of the comments that have been made. We have had the same comments at the Roads and Parks Department for the whole time. The transfer of Big and Brown Road to the city and the transfer of Alta Vista Road to the city. Mr. Brinkley actually has responded to James Philp, our county engineer, an email saying, oh yeah, we missed that, we'll add that. So we were under the assumption all along through this process, and we weren't sitting on the sidelines watching, letting things happen without us. We were actively engaged in providing those comments, and we were frankly led to believe that these roads were going to be transferred, and then we were a little bit surprised when we saw, you know, the final map that was approved and they weren't included. So I do want to take the time on the record to clarify that, because it's important for me from our department's standpoint. What I think I heard Mr. O'Connor say was that I just want to clarify that they're okay with accepting jurisdiction of Alta Vista from Brigham Brown to Riley Road, as it does appear to qualify as a nexus road within the IRMA. That's our interpretation of it. That traffic impact analysis that was referenced by Mr. Brinkley, we've reviewed it. I was looking it over this morning. We've worked quite a bit with Ms. Parducci from Southern Oregon Traffic Engineering, who put that together. You know, when we see impacts like at the intersection of Alta Vista and Riley Road, that, you know, are pointing towards a 42% increase in turning motions and trips at that intersection, you know, during peak PM hours when this development is built out. To us, that feels like a significant impact. You know, you know, it feels pretty important, and it feels that road is part of a circulation plan for that development. So I don't think there's any doubt in the world from our department's standpoint that Alta Vista qualifies as a nexus road. I was a little confused when I was listening to the proposal, and I just want to take maybe an opportunity to get an answer and clarify that in regards to Big and Brown Road. At first, I was thinking that the applicant was suggesting to, through this process, that they would work with the city to request jurisdiction of Big and Brown from the southern portion of this development or UGB expansion to Alta Vista, but then maybe it sounded like they were talking about just as the proposed UGB expanded area abuts Big and Brown, which then still would leave that gap in a road in that part of that's adjacent to the part in this area that is not being incorporated, right, or up for it. That concerns me, just because of the continuity of city services that we've talked to. Then we start seeing improved roads, sidewalk ends, right? Kids are on that sidewalk, they're traveling on that sidewalk to get right up the road another few hundred feet to Alta Vista, where the city services begin again. Then they're pushed out onto a really narrow travel lane with zero you know, bike lanes or even paved shoulders for that matter, and we do see traffic on that same traffic impact analysis. You know, we shows an additional 1,280 trips on Big and Brown. That's a road right now that, per our most recent traffic studies in July of 2025, has a count of about 2,200. So that's over a 50% increase. You know, we're not talking about I-5 numbers of roads, but when you look at percentage increases, whether it's an intersection or a road, these are big percentage of increases that people on the south end of Eagle Point are going to see. And that impact's going to be felt on a narrow rural road that was developed and designed and built for the last several decades to handle rural level, you know, types of traffic, not traffic where a major road connects to this. From a leverage standpoint, I have concerns that if this is not implemented as was, you know, recommended by staff, you know, how we may or may not see these roads transferred over to the city, especially Big and Brown, at a later date. Then we are all of a sudden the permitting agency on Big and Brown. They're having to meet our standards versus city standards, which that should be the goal in all of this, in my opinion, is as cities urbanize out, we have the city standards being used. So eventually in another 10, 20, 30 years, when they urbanize onto the other side of that road, those roads are meeting city standards, not county standards at that point. So it's important to me that when development occurs, the city is the permitting entity on that, and the city is working to ensure city standards are being met. From a leverage standpoint, I think maybe what I heard Mr. Brinkley say was, if this was the way that the board decided to go, then we just simply don't issue a road approach permit. And from our department, that's really the only thing that I can think of that we have leverage with, is when the applicant comes in to apply for a road approach permit onto Big and Brown, we just simply say, we're not issuing this until the city takes jurisdiction of this road. That's an awkward position for the department to be in, right? But not saying it couldn't be done.
Thank you. Any questions for Steve?
Thank you. The only other point I would say is we've been very engaged with the city. I had a meeting a month and a half ago with Mr. Prunty, their planners, their transportation folks, told them to expect a recommendation coming from the staff with the exact recommendation today. So they had plenty of time to expect this. It wasn't an ambush at the end. Thank you.
Can I have a quick?
Yes, please.
Just to clarify, and you testified at their city meeting last summer as well on these road issues. Isn't that correct?
Not me.
Oh,
no,
you didn't?
No, our department didn't. No, there's been a lot of discussion. Mr. O'Connor started his presentation, which I think was great, showing the map of roads and confusion over jurisdiction. We've never had confusion over jurisdiction. We know Alta Vista is ours from Big and Brown to Riley Road. In the past year, we've gotten calls from the city saying, hey, do you guys have jurisdiction of X road? Why aren't you doing this? And then we're able to go back and say, actually, that was transferred to you about 20 years ago. It's been your road for 20 years. So that confusion is not something that's new. It's not on our department's side of things. I'll just clarify that.
Great, thank you.
Thank you.
Okay, and applicant can rebut if you'd like.
Is there more testimony?
Well, I don't.
Dan O'Connor. Yeah, I just think the mechanism, the condition of approval, which is commonplace with jurisdictions, agencies, that sort of thing, is a perfectly acceptable mechanism to ensure that the section of roadway. And to respond to, I understand and appreciate, and I think we're in alignment that I would, on pushing the city of Eagle Point, I don't know if they even need to be pushed, I don't know if that's the right word, is not to have gaps in the jurisdictional transfer. I mean, from Alta Vista, not have a gap. But keep in mind, I mean, these street improvements are almost always developer driven on this type of thing. So even though there's a jurisdictional transfer of that whole section, because we do not control that property adjacent on the northern end, there could still be a circumstance where that road would still be basically at county standards until it's improved. And that's where you see it all the time, all over the place. And that's where the sidewalk in sign, where the urban improvement until such time that property is developed. And that's all I have. Thank you.
Okay, thank you. And nobody else in here? Any other speakers wishing to discuss? Okay. Well then, with that, we will close the public hearing and we'll move on to deliberations. I'll let
Is there exhibits, a number of exhibits to enter?
There are 22.
Could I make that motion?
Yeah.
Mr. Chair?
Yes, please.
I make the motion to exhibits 1 through 22 into the Board of Commissioners record for file number 439-26-00002 LRP, and to close the record.
Second.
Commissioner Roberts?
Yes.
Commissioner Sparacino?
Yes.
Commissioner Dyer?
Yes. Now we'll move into deliberations. So I think certainly trying to be as flexible as we can and work with developers. I mean, the reason this, 1537 was approved was to get things done more quickly. We need housing. We need, we need this type of development, understand that, and I think we're sensitive to that. We also need to make sure that we do our due diligence as representatives of the county, and of course on this land use decision, to make sure that we are prudent in what we condition and try to ensure happens from this process. And it appears to me, and I would probably agree with Mr. Lambert, that conditioning now, doing what we can now to ensure that without leaving potential conflicts and disputes hanging, I think is our most prudent move. And again, if there is a gap in what was approved from where Robert Trent Jones comes out to Big and Brown to Alta Vista, that should be also included in that jurisdictional transfer.
Well, I agree. I'm for the development and expedited process, and I think it's the first one in the state. So I think getting it right is kind of important for others to follow. Obviously, from reading the city's ordinance, they even missed the IRMA. I mean, if they're willing to take in the jurisdictional transfer of Alta Vista, they're going to have to amend the ordinance, I would assume, anyway. And I think considering both roads with the transportation plan that justifies it is just, for safety, I think meeting the concerns of the citizens I heard that were concerned about transportation to this big development that's growing on both sides of the road is significant to consider.
Ready?
You guys said it.
Do you want to?
Yeah, we'll take a motion then.
So I'll make the motion. Based on the evidence and testimony, I move to approve with conditions the application for a major comprehensive plan map amendment and add 85.9 acres to the City of Eagle Point urban growth boundary pursuant to Oregon State Senate Bill 1537 in 2024. The property is described as Township 36 South, Range 1 West, Section 10, Tax Lot 1202 and 1203, and Township 36 South, Range 1 West, Section 11C, Tax Lot 300, and located at Big and Brown Road and Alta Vista Road, Eagle Point, and it's Eagle Point Bigum Development LLC is the applicant, and its file number 439-26-00002-LRP.
Second.
Commissioner Roberts, can I just clarify that your motion includes the condition recommended by planning staff?
Yes, thank
Thank you.
you. As amended, you second that?
I second it.
I thought with conditions was identify enough, but
Yeah.
yes,
Commissioner Roberts,
yes.
Commissioner Sparacino,
Yes.
Commissioner Dyer.
Yes, okay, and with that, I will ask staff to prepare an ordinance of approval and set dates for the first and second reading and public hearing of the ordinance. First reading on June 3rd, 2026 at 9:30 a.m. here in the courthouse auditorium, and the second reading for June 17th, 2026 at 1:30 p.m. here in the courthouse auditorium. And with that, we'll adjourn the meeting. Really? Sick. I started feeling bad last night. Oh.